Enzo Recto, kalaban ang katiwalian at kasinungalingan, kakampi sa katotohanan at kabutihan.
Magandang araw mga kabunyog. Komentaryohan natin ang ilan sa mga maiinit na pangyayari sa Senado kaugnay ng usapin kung itutuloy o hindi ang impeachment trial ni Vice Presidente Sara Duterte. Sa nasabing hearing, kapansin-pansin ang naging performance ng batikang senador na si Tito Vicente Sotto III. Kahit hindi abogado, hindi siya nagpahuli sa talino at tapang sa pakikipagdebate. Sumabay at lumaban sa mga kapwa niya senador na may titulo bilang abogado. Sabi nga ng ilang nakapanood, hindi pa yan abogado, pero kung makipagsagutan, talo pa ang mga lisensyado. Ngayon, mga kabunyog, ang tanong, sana naman yung iba riyan ng mga dating artista na naging senador din. Tulad ni na Robin Padilla at Sina Lapid, maging ganun din ka-prinsipyo, may paninindigan at hindi sunod-sunuran lang. Lalo na yung isa riyan na literal na tuta ng Duterte, palaging nakaabang kung ano ang iuutos mula sa taas. Anyway, panoorin natin ang mga kaganapan sa Senado kung saan tumindig si Senador Tito Sotto at ipinakita na ang talino, tapang at prinsipyo ay hindi lang para sa mga abogado.
So, listening to the privileged speech of the distinguished gentleman from Tarlac, the basis of your motion to dismiss is the Supreme Court's decision, which is now pending appeal by virtue of the MR or the motion for reconsideration filed last Monday by the House of Representatives. Is it not, Your Honor?
The question whether is it
Yes, your
subject
basis
to
for your motion to dismiss is based on the Supreme Court decision that the so-called impeachment is unconstitutional, based on their decision.
Yes, Mr. President, Your Honor, that's very, very clear and categorical.
Correct. The Supreme Court decision, Mr. President, although immediately executory, is not yet final. Thus, appealable. Ngayon, naka-appeal na. Marami nagtatanong, kung naka-appeal na, ba't tayo nagmamadali? I-dismiss ito sa atin. So may I ask the gentleman, what will happen if we prematurely dismiss the case and the Supreme Court subsequently grants the MR and reverses its own decision?
The question, Mr. President, is speculative.
Yes. May I have a speculative answer, Mr. President?
We cannot speculate. We can only guess, second guess, because on the basis of our experience as a practicing lawyer, Mr. President, ito pong ganitong klaseng desisyon, talaga pong wala na pong kaduda-duda na kahit po mag-file pa tayo ng motion for reconsideration. We are hoping against hope. It is as if we are wishing for the moon. Palagay nyo lang po merong isa na nag-reverse. Hindi rin po ma-overturn eh. Kasi po ang kailangan po ninyo ay 8 ang mag-reverse. Sa inaakala po ba ninyo meron kayong makukuhang 8 na pumirma doon sa unanimous decision na babaligtarin po nila yung kanyang sarili. Kaya napakahirap pong mag-speculate, Mr. President.
I will accept the answer of the gentleman, but I have done my research, Mr. President. And to remind everyone, the reversal of the Supreme Court's own decision is not impossible, even in landmark cases. In the case of Labugal, Bilaan Tribal Association Incorporated versus Victor Ramos, GR number 127882, December 1st, 2004, questioning the constitutionality of Republic Act 7942 or the mining law, the Philippine mining law. The Supreme Court granted the MR, reversing and setting aside its earlier ruling. And also, Mr. President, just a few days ago, the Supreme Court reversed its own ruling on the definition of a stockholder. This is the case of Lily Lopez versus Lolito Lopez with GR numbers 25497-957-58. So, may kasabihan po tayo, ang tumatakbo ng matulin, kung matinik ay malalim. Kaya dapat siguro pag-isipan muna natin kung tama ba na bago magdesisyon ang Supreme Court, basta ibasura na natin ang kaso na ito.
Unang-una po, Mr. President, gusto kong malaman, yung po bang mga kasong sinabi nyo, unanimous decisions po ba lahat?
I am not sure about that. But one thing I can say is that if there is a mistake, a unanimous decision could become a unanimous mistake.
Wala pa pong nangyaring gano'n, Mr. President. At saka po tayo, pag nananakbo, ako po ay nakasapatos at saka sa kalsada kaya hindi po ako matitinik.
Well, Mr. President, there's always a first time. Regardless of whether it's unanimous or not, unanimous decision does not bar an appeal or a reversal, Mr. President. That is one thing for sure. Now, secondly, where is the ball, Mr. President? Or meaning the impeachment case itself? Is it in the Senate or in the impeachment court? Didn't the impeachment court throw it back, remanded, returned to the House of Representatives? So what are we dismissing in the Senate kung wala sa atin ang kaso? Can we continue hearing the case and dismissing it without the impeachment case in our hands? Can we throw the ball out when the ball is not in our possession? Siguro naman dapat magkaroon tayo ng tinatawag nating sense of proper sequencing of moves. Nasaan po ba yung impeachment case?
Mr. President, kanina po sa aking clarificatory statement, ang sabi ko nga po, yung ginawa pong initial proceedings noong 19th Congress Senate, yun po ay nangyari sa panahon po ng 19th Congress at lahat po yun ay naisantabi lahat sapagkat natapos nga po ang termino ng 19th Congress on June 30, 2024. Kaya po natin sinasabi, Mr. President, na dinidismiss na po natin ngayon sapagkat tayo po ang nasa lugar na sinasabihan ng Korte Suprema nung sabihin niyang ito ay immediately executory. Sino pong mag-i-execute nun? Hindi naman po i-execute yun ng House of Representatives. Maliwanag naman po na tayo lamang ang tinakdaan ng kataas-tahasang hukuman na gumawa ng paraan para isang tabi na po ang usaping ito sapagkat napagtibay nga nila na ito'y unconstitutional, void ab initio, at wala na po tayong jurisdiction para dito.
Thank you, Mr. President. Your Honor, thank you. But as I said earlier, not because it is immediate and executory does not mean it's not appealable. Now, to continue, Mr. President, I hope you don't mind. I will be posing a question, but then I will be doing a manifestation based on this question that I will be posing. So I'm certain that the gentleman from Canal Rock has read the 97 pages ruling of the Supreme Court to come up with this motion. So the question is, must we agree on the statement of the decision of the Supreme Court on page 3, page 56, as basis that the one-year ban has set in? With that question, allow me to proceed with my manifestation, with your permission, Mr. President. For the benefit of our colleagues, my colleagues, the last paragraph of page 3 states that, quote, since the 19th Congress terminated, the 3 impeachment complaints became enacted upon, end of quote. Again, this was reiterated in page 56, second paragraph of Roman numeral 5. It says, quote, the House of Representatives, however, was unable to act on the first 3 impeachment complaints because of the adjournment of the 19th Congress. To continue, for constitutional purposes, the first 3 complaints were effectively dismissed. In both instances, Mr. President, the Supreme Court was referring to the February 5, 2025 adjournment. But they have, erroneously believed that the said adjournment is the same adjournment with a sine die adjournment that ends a Congress. It is not. February 5 did not terminate the 19th Congress as stated in the decision. The sine die adjournment of the 19th Congress was on June 13, 2025, wherein the last session day was last June 11. Mr. President, and for the information of the public, there is a world of difference between adjournment versus adjournment sine die. Sa atin, pag nag-adjourn tayo for the Christmas break, nag-adjourn for the Easter break, nag-adjourn for the election period, nothing dies. treaties, bills, resolutions, anything filed continues. It does not, it is never archived. Well, perhaps the lawyers of the ponentes did not realize that, or they were not familiar with the rules of Congress. As I said, this is a world of difference. Now, this is a transcendental case. Ang laking constitutional issue. Wala man lang oral arguments, or at the very least, a consultation with some members of Congress or members of the bar na nakakaintindi ng rules ng Congress regarding the procedure. In that matter alone, Mr. President, kasabihan ninyo mga lawyer, falsus omnibus, falsus unos, falsus omnibus. Mistake in one, mistake in all. In that manner, they wouldn't have decided based on their unfamiliarity with the legislative process. Eh, may mali agad eh. Pati ba legislative rules natin gusto nilang palitan? Ganun ba yun? Maybe not everyone may appreciate the importance of the legislative calendar of Congress. But us, it is a big deal. That's why I'm stressing this point. Concurrent joint resolution pa nga when we approve this calendar, only to be misinterpreted and used erroneously in this case. Nag-adjourn daw yung 19th Congress. Kaya na-archive lahat. Now, may kinopya lang, kopya, mali pa. Sabi nga kanina ng ating distinguished gentleman from Tarlac, hilaw. Hilaw yung complaint. Eh, hilaw din yung decision. In addition to this factual error, Mr. President, it can be seen in the website of the House of Representatives that the 3 impeachment complaints were referred to the Committee on Rules and were consigned to the archives on February 6, not February 5, as claimed in page 78 of the decision. Nag-housekeeping lang ang House, kaya in-archive, hindi to end the Congress. This archiving were not the results of the ending of the 19th Congress, but because of the fact that the 4th complaint were already filed and transmitted to the Senate. Eh dito pa lang, Mr. President, pilit na patunayan na barred ang 4th complaint. Kapag ayaw, may dahilan. Kapag gusto, may paraan. Now, to continue, Mr. President, and this is very much related, the Supreme Court, by the way, if it is wrong, if the complaint done by the House of Representatives was wrong, we cannot correct a wrong with another wrong. The Supreme Court essentially amended the Constitution by removing the 3rd mode of filing of impeachment complaint. This 3rd and speedy mode was enshrined there for a reason. In times that there is an urgent need to impeach a person who is influential and powerful and may use his position to evade the law, the 3rd mode, which is the fastest way, was provided in the Constitution. Why don't you ask the authors of this provision in the Constitution? Constitutionally, Sir Code delegates Munsod, Ascuda, Sarmiento. So, Mr. President, continuing, if the Supreme Court is now changing the meaning of initiating, then at the very least, please apply it prospectively. However, they are applying this new ruling retroactively, which is a violation of the doctrine of operative facts. Kung ganito kanilang kagustuhan, at susundin natin basta-basta, apektado din dito yung nakaraang impeachment, the impeachment proceedings. In the words of retired Supreme Court Senior Justice Antonio Carpio, I quote, "The said Supreme Court decision practically voided the impeachment proceedings against former President Joseph Estrada and former Chief Justice Renato Corona." Pag gusto talaga, may paraan. Pag ayaw, may dahilan. Pero wag naman sana pati sa mga ganitong bagay that will ultimately affect future impeachment and legislative rules and proceedings. Sa atin yun eh. I've read that the basis for the retroactive application of the new definitions because the Senate now has not acquired jurisdiction yet. Mr. President, ano tawag natin doon sa nag-constitute kayo as an impeachment court? Nag-robe pa kayo. You even sent out summons. Ano yun? June 9, the Senate President took his oath. June 10, nag-convene an impeachment court. Niremand to the House of Representatives. Tapos yung issue of the summons to the defense. Ano po tawag doon? Hindi nag-convene? Baka hindi nabalitaan ng Supreme Court na hindi nag-convene. Kaya naisabi nila yan. So,
Senator Pangilinan.
now, just...
Senator Sotto.
I register my vote, Mr. President.
The Minority Leader may proceed.
Thank you. Mr. President, the Supreme Court decision is now pending appeal. It is prudent to wait for the results rather than prematurely archiving, if not dismissing, because I know for a fact, once it is archived, it is dead. So what happens if the Supreme Court reverses itself? Clear and blatant errors are present in the ruling of the Supreme Court. First, they misunderstood the legislative process in assuming that the 19th Congress adjourned sine die in February 5. Grave error. Thus, effectively dismissing the first three complaints, paving the way for them to say na ano pala, yung 1-year ban binayolate. The archiving of the three complaints were done after the initiation of the fourth complaint. The 1-year ban did not set in. Second, the decision practically amended the clear mandate by the Constitution by placing a hierarchy on the modes to initiate an impeachment complaint. Parang wala na yung third option. Third, the Supreme Court retroactively applied the new definition to the present case in the violation of the doctrine of operative facts, thus voiding as well the impeachment proceedings of former President Estrada and Chief Justice Corona. They did not interpret the Constitution, Mr. President. They amended the Constitution. So lastly, the Supreme Court now has the chance to rectify these errors in its decision. So I was hoping to table the motion so that let us afford them this opportunity for the benefit of future impeachment processes and to uphold the clear mandate of the 1987 Constitution. All we needed to do was wait a little. And so I will have to register a yes vote. I know it will be a vote in the minority, but I've always voted in the minority in many issues in the Senate since 1992 up to the present. Always prayed I was wrong. Unfortunately, I was always right. My God, have mercy on your decision. I vote yes.
Noted.
Yan mga kabunyog, narinig at napanood natin kung gaano katalas ang isipan at katibay ng paninindigan ni Senador Tito Sotto. Buong tapang niyang ipinaglaban na ituloy ang paglilitis kay Sara Duterte. Hindi tulad ng dalawa pang senador na dati ring artista na kung ikukumpara kay Senador Sotto, wala talaga sa kalingkingan, kulang sa prinsipyo at parang sunod na lang sa agos. Ngayon mga kabunyog, panoorin natin ang naging boto ng dalawang ito at ang kanilang paliwanag kung bakit nila piniling i-archive na lang ang impeachment case ni Sara. Sa madaling salita, ibasura na lang at huwag nang pag-usapan pa. Abangan at pagmasdan ninyo kung anong klaseng katwiran ang kanilang ibinato sa taumbayan.
Mr. President, rinirespeto ko po at ginagala ko ang kataas-taasan hukuman. Ang boto ko po ay yes. Salamat po.
Maraming salamat, Senator Lapid, Secretary.
Senator
Maraming salamat po, Ginoong Pangulo. A'udhu billahi minash shaitanir rajim. Bismillahirrahmanirrahim. Alhamdulillah rabbil alamin. Bismillahi wassalatu wassalamu ala rasulillahi. Assalamualaikum warahmatullah. Alam niyo po, ito na po siguro ang pinakamaligayang araw sa buhay ko sapagkat makasaysayan. Ako po ay nagpupugay at malalim na paghanga sa isinagawang paliwanagan ni Senator Marcoleta, Senator Sotto, Senator Ontiveros, Senator Lacson, Senator Pangilinan, Senator Aquino, Senator Pia Alan Cayetano, Senator Raffy Erwin Tulfo, Senator Mig Subiri. Ang palitan ng mga paniniwala sa plenaryo ay simbolo ng humihinga at buhay na Senado. Nagagawa natin ang kalayaan at kasarinlan. Isang demokrasya na naririnig ang bawat naratibo. tagahanga po ninyo ako lahat. At alam naman po ninyo, sa maiksing panahon ko rito, ako ay pro-Westminster. At ngayon, system po, system. Yan po yung parang sa UK. At yan po yung nakita ko ngayong araw na ito. Ang lahat ng mga senador ay gising, ang lahat ng mga senador ay nandito, ang lahat ng mga senador ay nagtatrabaho sa ayon sa kagustuhan kong makita ko ang bawat debate at ang bawat opinion ng bawat isa. Kaya nagpapasalamat po ako. Napakagandang araw po nito sa inyong lahat at sa ating lahat. Ngayon, mga kababayan, gusto ko pong malaman ninyo na ako po ay nagbibigay pugay sa lahat ng nanonood sa atin ngayon. Malamang, ang sasabihin ninyo, siyempre si Robin Padilla, ang boto niyan, alam na natin. Mabuti po, alam nyo na. Ang gusto ko lamang pong liwanagin ay ito. Ang nais ko, sana, ay katapusan na nito. Dismissal. Una pa lang po, bago pa lang po kami na-convene, labag na po sa kalooban ko na matuloy ito. Nakita nyo naman po, noong nagkasumpaan, talagang ipinaglalaban namin na politika ito. Politika ito At kailangan ng due process. Pero natuloy pa rin po, nag-convene pa rin. Pero hindi pa rin po ako nagsuot ng robe dahil para sa akin ay protesta. Dahil ayoko po talagang matuloy. Bakit? Sa loob po ng matagal na panahon ni Bonifacio, ni Aguinaldo, panahon ni Aguinaldo, ni Quezon, panahon ni Marcos Sr., ni Aquino Sr., ni Aquino Jr., ni Arroyo, Marcos Jr., PRRD Duterte, HOR ngayon, at Vice President Duterte. Hindi na po tayo natapos sa usapin ng politika at yaan po ay pinagtibay ng Supreme Court sa kanyang desisyon na sinabi niya mismo, oo, politika lang impeachment, pero hindi kailanman dapat masagasaan nito ang karapatan ng tao. Malinaw at yun po ang pinaglalaban natin at kailangan dumaan sa tamang proseso at yan po ang pinaglalaban natin. Ngayon, mga mahal kong kaibigan, pagkatapos po natin marinig ang bawat punto ng bawat isa, sana po matapos na po ito at harapin na po natin ang mga tunay na problema ng bayan. Katulad po ng sweldo, katulad po ng agrikultura, pagkain, kaguluhan sa West Philippine Sea, sa buong mundo. Ang dami po nating dapat pag-usapan. Total, meron pa naman pong Pebrero ang sinabi naman po ng Supreme Court at ang Supreme Court naman po, ang siya naman po dapat na sinasabi ng saligang batas. Malinaw po. Matagal po akong ginawang chairman ng constitutional ni dating Pangulo Mig Subiri. Pinagkatiwalaan niya po tayo, pinag-aralan po natin yan at malinaw sa konstitusyon na ang magpapaliwanag ng saligang batas ay Supreme Court. Kaya sana po, ako'y malungkot talaga dahil napunta tayo sa archive. Yung archive, binasa ko pwede pala yan hukayin anytime, kung ano man. So, hindi pa rin tayo natapos. Kaya sana po, bagamat ang boto ko ay yes, aray. Gusto kong malaman at mailagay po sa lathalan ng Senado na ako'y may reserbasyon dyan. Malaking reserbasyon ko dahil gusto ko dismissal. Tapusin na natin to. Hindi pa tayo natapos Total, nasabi na lahat. Ilang oras ang banatan. Pero hindi pa rin natapos. Kaya po, mga mahal kong kababayan, bago po ako umupo, nais ko pong malaman ninyo na ang inyong Senado ay tumatakbo. Huwag po kayong malungkot sa mga hindi pabor sa amin o sa mga pabor naman. Isa lang po ang masasabi ko. Tigilan na natin ang politika at mahalin natin ang bawat isa, magkaisa na tayo, pag-usapan natin ang mga totoong problema. Maraming salamat po.
Thank you, Senator Robin Hood Padilla, Madam Secretary.
Senator Pangilinan.
Senator Francis Kiko Pangilinan is recognized to explain his vote.
Yan mga kabunyog, napanood natin ang naging paliwanag ng dalawa pang senador na sa totoo lang, walang ipinakitang prinsipyo at paninindigan. Sunod sa agos ang isa at yung isa naman parang basta lang may masabi. Kung ano ang uso, doon siya kakampi. Parang walang sariling isip. Sayang, para saan pat naging senador ka kung ganyan lang ang ipinapakita mong asal? Pero bakit nga ba itong si Senador Tito Sotto ay ibang-iba sa kanila? Pare-pareho naman silang dating artista, hindi ba? Ang sagot, mga kabunyog. Dahil si Sotto ay may paninindigan. Laging nakatindig sa tama. Bukod pa riyan, malawak ang kanyang karanasan sa serbisyo publiko. Kaya kahit pa kapwa senador na abogado ang kaharap, hindi siya nagpapasindak. Sinusupalpal niya kung kinakailangan. At yan po ang ating komentaryo sa araw na ito, mga kabunyog. Mabuhay ang katotohanan at mabuhay tayong lahat.
Bunyog, bunyog, halikan na kasama ka. Bunyog, buklod ay may pag-asa. Luzon, Visayas, Mindanao, isa ang pananaw. Sa bagong Pilipinas ang bunyog isisigaw. Bunyog, bunyog.